All right, guys, we're on Amendment number 6 of the Constitution. So, Amendment number 6, written in 1791. Like the Bill of Rights was written, you could say simultaneously around the same year. So, this is the 6th Bill of Rights, the 6th Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. I want to say this compulsory process for obtaining witnesses, I want to say those are what you call subpoenas. So Amendment number 6, let me try to decipher it myself. So Amendment 6, accused shall enjoy the right to a speedy trial, um, in a public trial, speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and be informed of the nature and cause of the accusation, to be confronted with the witnesses against him. Okay, so the Sixth Amendment is appropriately considered the centerpiece of the American criminal justice system. The American piece. So it's pretty much establishing the one of the biggest branches of our three branches of government, which is the judicial branch. In addition to guaranteeing all criminal defendants a trial by jury, it provides an outline of the basic procedures to be followed in such trials. The trial shall be a speedy one, which is to say that accused criminals cannot be imprisoned for lengthy periods of time before receiving a trial. The trial must be public. The framers of the Sixth Amendment specifically rejected the format of English Star Chamber proceedings. That is, proceedings held in private, away from scrutiny by the public. The juries in criminal trials should, in normal instances, be drawn from ordinary citizens who are resident in the state and region where the crime was committed, although in unusual cases, if the crime is of such a sensational nature that it might prove impossible to impanel an impartial jury, the trial might be held in a jurisdiction other than the one in which the crime was committed. I want to say I can't see no instance where that would occur. I mean, I can't really see one. I mean, the Sixth Amendment also guarantees to the accused the right to be confronted with the nature of the charges brought against him, the right to confront either directly or through an attorney the witnesses against him, and the right to present witnesses in his defense. Finally, criminal defendants are entitled to assistance of counsel, that is, a competent attorney to assist them in their defense. So the right to an attorney, even a court or a court appointed one, a public defender, that is a competent attorney to assist them in these basic guarantees have been elaborated in countless court cases in the more than 200 years since the amendment was ratified, and through the incorporation doctrine have become the standard procedure for criminal trials in states and other localities as well as in federal courts. So amendment number 6, I'll call this the judicial amendment. Trial by jury, speedy trial, right to counsel. Just some notes, you know. So amendment number 6 of the Bill of Rights.